الدارات المعرفية العربية، الواقع والمأمول. أنا الحقيقة فقط نحب نعبر على سعادتي كوني أنا نترأس جلسة فيها الأساتذة اللي هما أنا درست عندهم في المعهد للتوثيق لإغرار الدكتورة يسرا والدكتور خالد الحبشي. إذا ننطلق بالمداخلة الأولى. دكتورة سارة بونسن، تفضل.
Can everyone hear me okay? All right, great. So my name is Sarah Benson. I'm from the University of Illinois Library in Champaign-Urbana, Illinois, which is just about 2 or 3 hours south of Chicago. So I invite any of you who make it to the United States one day, if you're in Chicago, please look me up, and I'm happy to entertain you as I've been entertained here. I am a lawyer and a librarian. In the United States, we call this a lawbrarian. That's really a joke, but more seriously, it's very rare actually to have both degrees, and I focus my research on copyright law. I want to thank the conference organizers for bringing me to beautiful Tunisia. It really is my pleasure to be here. I feel very fortunate that I have been able to visit this country, and I want to thank the Arabic Union Catalog for inviting me and sponsoring this talk, and I also would like to thank Mona for translating for me yesterday so that I could respond to some of the concerns and thoughts that you have that I heard expressed. So today I'm going to talk about copyright law in the United States, which creates conditions that are favorable not only for libraries to work together, to lend library materials through programs such as interlibrary loans, but also to be able to share digital copies of entire works for the good of the public. In this talk, I'm going to highlight areas of United States copyright law that allow for such digital library practices to take place, as well as how libraries in the United States have been pushing the boundaries of the law in order to further advance such collaborative efforts, and hopefully to inspire you for the future of the Arabic Union Catalog and for changes in your own country's laws. The United States, like many of the nations represented here today, is a member of the Berne Convention, which is a copyright treaty that provides for international, transnational respect for copyright laws or law enforcement national status for different enforcement of copyright protections. Tunisia, for instance, joined the Berne Convention in 1887, which is just after it was convened in 1886. The United States, however, was quite far behind Tunisia and did not enter Berne until 1989, which is quite later. Why? The United States was very tied to its own copyright formalities, such as requiring that a copyright symbol be included in order to enforce copyright, and also requiring registration prior to a copyright being enforceable. We also had a lack of moral rights, and I would argue mostly we still have a lack of moral rights in the copyright law of the United States today, such as attribution, the right to be forgotten, etc. And the United States really was tied to its own laws and did not want to change them, and so joined Berne quite late. This makes copyright law in the United States quite difficult because it changed so many times over so many periods, and those changes were not retroactive to the previous periods. And so you have varying targets of what copyright required in different eras, making copyright law in the United States probably more complex than some of your laws. If you join Berne, then they're more standardized. So when I begin copyright lectures in the United States, I tend to ask, who in the room owns a copyright? By show of hands. I won't, oh, so I see some people participating. Good. And in the United States, almost no one raises their hands. That's because in the United States, copyright literacy is far from where it should be. One of my roles is to advocate for more informational accuracy and more knowledge about copyright in the United States. For instance, like your countries, we don't need to put a copyright symbol on our work or register our copyright with the Copyright Office to own a copyright. And I normally point out to my students, yes, indeed, many of you own copyrights. You probably own many. So where does copyright law fit? We were talking about intangible rights yesterday. Copyright law fits into this area of intellectual property law. And there are three various types. There's copyright, there's trademark, and there's patent. I'm a specialist in copyright. I know enough about trademark to be what I call dangerous, and so little about patent that my advice would be horrible. But where does copyright fit? So copyright protects creative works. Creative works including software, writing, which our libraries hold, artistic works and sculptures, architectural plans, musical scores and recordings. It does not protect facts, ideas, short phrases and titles that might be trademarked. So if you think of the Nike Just Do It or the swoosh mark itself might be a copyright and a trademark, but Just Do It is too short of a phrase to be copyrightable. It is merely protecting a brand, such a trademark. It also does not cover methods of operation or useful articles or inventions, which would be patent law. So I just want to situate where we are. What does copyright law protect in the United States? As I mentioned earlier, it's automatic. Once a minimally creative work or an original work is fixed. What does it mean to fix a work? It means you record it, you write it down. My copyright slides for today are protected as I've written them down. And copyright in the United States today lasts a very long time, the life of the author plus 70 years. Now, as you might be aware, the Berne Convention requires a minimum of the life of the author plus 50. So I'm assuming many of your laws, that may be the default. The longest copyright law that I'm aware of is life of the author plus 100 years, which is the law of Mexico. What rights do you have when you have a copyright? You have the right to reproduce the work or make copies of the work, the right to distribute the work, including through the internet, the right to create derivatives of the work, including translations. So translations do constitute a derivative work, to perform the work, such as a dramatic play, or display the work, such as in a museum. So now I get to more of the heart of my talk. I want to focus a little bit on some examples of how the United States is pushing the boundaries of copyright law. The Internet Archive is a nonprofit digital library that offers free access to books, movies, and music, as well as 351 billion archived web pages. Why am I focusing on the Internet Archive today? Well, the Internet Archive has a very innovative and forward-thinking project utilizing Section 108H of the Copyright Act in the United States. Section 108H permits a library to lend, copy, and display a work that is in the last 20 years of its copyright protection, so long as the work is not commercially available at a reasonable price. So this section of the Copyright Act was actually a compromise made in 1998 when Congress enacted the Copyright Extension Act, extending copyright for an additional 20 years. At that time, like I said, copyright law has changed. It wasn't the date that it is today, which is the life of the author plus 70, but at that time it was a set 75 years from date of publication. And if you're familiar with Mickey Mouse, Disney was kind of pushing for that change. They wanted to protect Mickey Mouse from falling into the public domain and extended copyright from 75 years from date of publication to 95 years from date of publication. And of course, libraries were adamantly opposed to that change. It would lock up the public domain for an additional 20 years, which is indeed what happened. We had no works falling into the public domain in the United States for 20 whole years. However, the compromise that was achieved was Section 108H, which allowed libraries to lend works that were in the last 20 years of copyright. So they said, sure, we'll give you a little bit of leeway here, libraries. We know that you're good actors in the copyright world. You're not acting maliciously. We are going to lock down copyright for an extra 20 years, but we are also going to allow you to publish those works or distribute those works that are in the last 20 years of their copyright term. So since 2017, the Internet Archive has been digitizing entire works that are in the last 20 years of their copyright term and making them available online for reading. This is actually quite phenomenal. So what you can do is just go to this website, find an entire book that is actually in copyright, and read it. I want you to think about that, right? That's a big deal. That's progressive, even in the United States. And although Section 108H allows libraries to do this, it does not extend to the end user or the patron or the person who is accessing the website. So, the availability of the works through the Internet Archive, though, allows people to read those works and to use those works. And the Internet Archive considers itself a digital library and is allowed to do so. It doesn't necessarily allow me as a patron to then download and put that work on my personal website, for instance. But the Internet Archive has that ability. Now, this type of lending, of course, relies on an exception to United States law. So how useful is this to you? I would say it's an example of how digital libraries are thinking carefully about how they can utilize their own laws to push for copyright accessibility. And so even though it doesn't apply to your laws, it can help you think creatively, think outside the box, think innovatively. I heard the word innovative quite a bit yesterday. This is one way that in the United States, different companies, different libraries are thinking very innovatively about copyright law in our laws. Another example of libraries sharing works online is the HathiTrust Digital Library. The HathiTrust Digital Library is a digital preservation repository and a highly functional access platform. The HathiTrust provides long-term preservation and access services to digitized content from a variety of sources, including Google, the Internet Archive, Microsoft, and in-house member institutions. When they say in-house member institutions, they're talking about libraries such as my own at the University of Illinois, who take books in their collection and digitize them and send them through Google to HathiTrust. So there's kind of an intermediary there. This would not be possible without Google. Where do I talk about Google? So it couldn't be possible without Google. Why? Because Google makes the books readable. And they digitize much faster than we could. So even though you might want to digitize a book in your collection, you may not have the technology to do so. Many of the libraries in the United States had technology, but it would take many, many, many man and women hours of scanning. I don't know how many of you have scanned a book. It takes a while, right? It takes time to turn the page. You don't want to ruin the book, so you're being very careful. Well, Google has special technology where they can scan books very quickly. And this is something that it's very proprietary, so we don't know exactly how it works. They won't let anyone see how they do it or know what they're doing, but they do it. And in collaboration with libraries, Google is scanning these books, and then they're applying their software, which is OCR, which is ocular character recognition. It's making the work easier to read online. And then they're putting that into the HathiTrust Digital Library, as well as using it for their own Google Books project. If you know about Google Books, they have their own repository of these books. But this is a wonderful collaboration. If you can work with Google, I encourage you to. Of course, be careful because their lawyers make you sign all sorts of confidentiality agreements and all of that, and you want to know that they're working in your interest. You certainly want lawyers to look at those agreements, and you want to know what they're doing with your materials. But in the United States, this is a good thing. HathiTrust is a good collaboration. And so what are we doing with those works? So we've taken works, they're in copyright protected books. We're scanning the entire book. We're sending the book to Google. Google is then sending it back to us, or to Michigan, where they have the HathiTrust servers. They're uploading that readable file to the server, and then what? Well, can we make the book completely readable online? No, because United States copyright law will not allow us to, right? It does not allow distribution of the work. Even copying of the work is protected under United States law. As I noted, authors have that exclusive right. So how are we able to do this, and what do we do with the work? In the United States, we have a very broad limitation on copyright called fair use, and that is what they're exercising when they make use of these works. Fair use is located in Volume 17 of the United States Code, Section 107, and in the preamble to Fair Use Code, it says, the fair use of a copyrighted work for purposes such as teaching, scholarship, or research is not an infringement of copyright. That's a very broad statement. Doesn't mean that everything we do for teaching is fair use, however, because it continues and provides these factors. In determining whether the use made of a work in any particular case is a fair use, the factors to be considered shall include the purpose and character of the use, including whether it is commercial or educational, the nature of the work, the underlying work, the amount taken of the work, and the effect of the use upon the potential market for or value of the copyrighted work. So are you replacing the market value of the work? But we have another layer to this. The Supreme Court in 1994 noted that a transformative use is also a fair use. And a transformative use is one that alters the original work with new expression, meaning, or message. Now, this has started to eat up fair use. There have been numerous studies that show that the more transformative the work is, the more likely it is to be a fair use, regardless of the other factors, whether it's commercial, whether you are using the entire work. Because the more transformative the work is, the less likely it is to impact the market value of the original work, because you're changing it so very much. So how does this apply to HathiTrust? If you look at a copyright protected work in HathiTrust, you cannot read the whole book. You can search inside the text. This is a screenshot from HathiTrust. You can find the frequency and the page number of specific words and phrases in the book. So, if you're searching for anaphylactic shock, which is when your heart stops beating, it's a medical term. If you search for that, you'll see this is a literal page from a screenshot from me doing the search in HathiTrust in a copyright protected book. What do we see? We see only page numbers and how many matching terms there are. How many times anaphylactic shock applies on page 11? 8 times. Why is this helpful? Why even do this? It's helpful because it tells the user, the patron, if this book is relevant. If I'm searching for a book for a medical research, and I want to know if this book is talking about anaphylactic shock. If it's not useful to me. Why check out this book from the library? Why buy this book? It's not useful. So, the court, of course, they were sued, HathiTrust was sued, and they defended the lawsuit on fair use grounds, and the court found that it was transformative. In fact, the court said it was quintessentially transformative. The court said the purpose of the original books or materials was for communication or reading, and yet the purpose of the HathiTrust research numbers was research, or to find out if you want to get that actual book. And so that is the end of my slideshow. What I would say is, to conclude, that your copyright laws, I've looked them up, not in their entirety, because many of them are not in my language. But a colleague of mine, Kenneth Cruz, did a study for the World Intellectual Property Organization, and he actually listed the interlibrary loan and preservation and lending provisions of every country in the world. And what I found was that Tunisian law, for instance, on interlibrary loan, allows only for a quote-unquote short extract of a writing published in a collected works or an article. But in the United States, for instance, for interlibrary loan, we could copy an entire book and send the entire book to a patron, so long as, on the basis of a reasonable investigation, the copy of the work could not be purchased at a reasonable price. So, say the book is out of print, we could copy that book and send it to a user. So I would say to you that your laws are great. You've joined the Berne Convention, you've joined the Marrakesh Treaty, you've gone farther, you've gone faster in some cases than the United States, in that we were very late to join Berne. But there are still ways that you can push the laws, and you can push for policies that might allow for more interlibrary loan that could actually work to the benefit of your users through the Arabic Union catalog. And this could be one of the ways, I hope that this talk has inspired you to kind of think about ways to creatively use your laws, as we have in the United States, to push the boundaries of copyright for your users. Thank you.
شكرا الدكتورة سارة بونسن. إذن حقيقة مداخلة ثرية وقيمة.